Pictured here are a couple people and a few organizations that have a little reason to be concerned. Of course, Sussmann is the person facing criminal charges, but their names are all over the indictment, littered all throughout the case. Of course, we know tech executive number one, Robert Joffe, seen here. We also know Marc Elias. He was the lawyer for Perkins Coie, which was the law firm for the Hillary Clinton campaign that actually went out and hired FusionGPS. And so we have a lot of these people now all intervening into the prosecution, saying, Judge, we know that Sussmann is under the prosecution, but we've got an interest in this. And so they're trying to insert themselves into the case, but they're not alone. A lot of what is happening, of course, surrounds Hillary Clinton, who also intervened. And so we're going to take a look at her motion to intervene because it specifically asks for permission to try to file documents under seal, file documents ex parte so that John Durham doesn't see them and so you don't see them. Let's take a high-level overview and refresh ourselves on what's exactly going on here. Michael Sussmann, we can see here in the top right, is the person facing criminal charges. And he, at the time, was working alongside Marc Elias, who was a lawyer at Perkins Coie, which was hired by the Hillary for America campaign. Perkins Coie was the company that worked with FusionGPS. FusionGPS was working with Robert Joffe, who was the person who helped concoct the Steele dossier and helped create the entire Russia collusion hoax. We know now that through this, Michael Sussmann was somebody who met with the FBI, Jim Baker. Jim Baker gave notes over to Bill and over to Tricia, who were sort of deputies there at the FBI. Sussmann also met with the CIA and multiple times with the FBI, communicating, saying, I am not here on behalf of Hillary Clinton. Turns out he was, and he knew he was. So that turns out it is lying to the FBI. We have an update from the court docket. We see here, Judge Cooper came out with a minute entry on April 19th, says, at the request of the defense, in this case, that's Sussmann, saying no objection from the government, that's Durham, saying the court's going to hear a couple expedited arguments on some defense motions. The motion in limine to preclude evidence, to keep evidence from coming in this case, it's Sussmann saying, we don't want Durham to be able to talk about those things. And also a motion to exclude the government's proposed expert witness. So we've got a big oral argument, it sounds like, taking place on April 20th at 10 a.m. So we'll certainly cover that. But the other interesting things that happened on the 19th were several motions to intervene. You can see the first one here coming in docket item 73. Motion to intervene by tech executive number one. It's this guy. It's Joffe. We know who he is. We have seen many of his emails, emailing back and forth with his team, telling them, oh, we know you can't really find anything, but go do it anyways. Signed here by the Judge Cooper saying, yeah, okay, file your motion. We see here there was another document entered in error, but let's look at the actual motion to intervene. This is over from Joffe. And what's his basis for trying to get involved in this case? Of course, he's listed in there in the indictment as tech executive number one, saying that he's filing this motion to intervene because he's got to get in there and exercise his rights, saying currently Durham, the special counsel's office, seeks to invade the attorney-client privilege, which he holds, which is held by tech executive number one. And so because they're trying to encroach on those privileges, he's saying it's appropriate now for me to submit my motion in opposition to the government motion, Durham's motion, to compel them to do certain things. And so we see that comes from Joffe. We have another one from Fusion intervening. Everybody sort of crashing into the front door saying, oh, shoot, Sussmann's case is still going on. The motion to dismiss the indictment, which we covered in a prior video, is denied, meaning the case and the prosecution is moving forward. And so now they're all trying to get in and, of course, exercise their defenses. Here is FusionGPS. We had a notice of appearance for their lawyer. They hired Kevin Patrick Crenny. He entered his NOA. Then we have another motion to intervene. And we have sort of a document that was entered in error. And so the court clerk is kind of entering things and then removing things. But we are able to take a look at these documents and see what's happening. I don't think this is any substantive error. It's just sort of an entry error. But here, let's take a look at this document coming from FusionGPS. Here's what they're saying. We oppose the government's motion to compel the production of the privileged communication. So we've been talking about the government here, Durham and the prosecutors, they want this evidence. They say, we need it. The defense has said, no, you don't. That's privileged. It's attorney-client privilege. We can't give that to you. And the prosecution is saying, well, if you're not going to give it to us, guess what we need to do? We got to compel the government, the court. We're asking the judge to compel the defense to disclose this stuff over to us. So they filed, Durham, a motion to compel the production of those documents. The defense, of course, Sussmann and these interveners, people like here FusionGPS, are saying, no, we oppose that. And so they're filing that now. They're also asking for an in-camera inspection by the court of the communications. And what that means is they're asking the judge to take a look at all this stuff behind the scenes, sort of in chambers is what we say, when they go back and they look at all of the documents off the record, something that is not done on the record in front of everybody to see because these documents might be a little bit too sensitive. We want the judge to take a look at it before they just start disclosing documents all over the place or making orders, yes, disclose it, or no, don't disclose it. It's saying, hey, judge, can you take a look at this? And then you can see what we're talking about and then make your decision. So FusionGPS is saying, yeah, we're asking for the court to, we're opposing the government's motion to compel us to give you this stuff. We don't want to give you this stuff. They're explaining why. They're saying here, withholding certain documents is necessary. It's protected by attorney-client privilege. They say it is related to its work that it did, FusionGPS, at the direction of Perkins Coie. Fusion saying, we were just working on behalf of the lawyers. The lawyers have the attorney-client privilege. They were engaged with Hillary, and we can't disclose stuff over to you because we were working under their umbrella, under sort of agents of them, which means that that attorney-client privilege extends over to them, right? If you're working on a case, for example, let's say we're working on a DUI case and we bring in a blood expert to come and analyze what's happening in that case. Well, that person may not be a licensed lawyer because they're a forensic scientist, but because they're working on the case, it's part of our work product and it sort of falls within the umbrella of attorney-client privilege. You don't want the prosecutor to subpoena your expert and say, tell me everything that your client talked about, right? That would negate your ability to form a cohesive defense. And so that's the argument that they're using here. FusionGPS is saying, look, we're not lawyers and we know we're FusionGPS hoaxers, but we are people who are working at the behest of this law firm. And so we think that that attorney-client privilege applies to us. Now they say, first of all, they say, we have been working on this for almost a year. And now, just weeks before trial, as we know this is scheduled in May, they say the government for the first time raises questions about these privileges, saying that this is totally invalid. They have no valid basis for the request to compel the in-camera inspection of these documents. So it's more that they don't want the judge to issue a ruling saying they have to compel the disclosure of it. They certainly don't want that, but they don't want the judge to even look at the documents. In other words, they don't want this in-camera inspection to happen. They're opposing the government and the attempt to get them compelled to disclose this stuff, but they don't even want the judge to look at it in order to make that decision. And so they go on, as you can see, for 33 pages detailing that. And if you want to read it, it's not that interesting, to be honest. I think that they're probably going to lose that because the argument goes from the judge, well, why can't I even look at it? I mean, can I look at it just to see whether I want to make a ruling one way or the other? They're essentially saying, no, they're saying the court has no reason to look at it because the government has failed to set forth a valid basis to compel the in-camera inspection of these documents. In other words, there's no reason for you to even take a look at it, judge. And I think judges kind of like to look at things, in my experience. And so I think the judge is probably going to err on the side of, well, let me look at it and then I can say no. But it's hard for me to make a decision about something until I've seen it. We know that another intervener has jumped in. This is Perkins Coie. They hired a lawyer. His name is Francis Joseph Warren. He entered his NOA, notice of appearance, April 19th. And then we see their motion to intervene. So now Perkins Coie, which is where Marc Elias, who is now sort of the founder of Democracy Docket, said that they needed to intervene. And we can see that something very interesting is happening with this intervention. Here, Perkins Coie, of course, is the law firm. And so they have arguably the privilege ethical duty as well. They've got to say, hey, we can't just sort of breach our attorney-client privilege here, judge. And so that's the argument they're making. They're saying, yes, we're also non-parties. We're also intervening only for the limited purpose of responding to Durham's motion to compel the production of these items. Also saying that they don't want the in-camera inspection to happen. You can see here they have a big opposition brief that they filed, but they're asking the court to deny the government's motion. Here's another document they filed, 3 pages. This one says, that they are submitting this response in connection with the government's motion to compel. And you see here that their argument is that Perkins, the law firm, has an ethical obligation to assert all the legitimate privilege claims made by clients in response to subpoenas calling for their information. So the clients are sort of invoking the privilege, and they're saying, well, we can't, allow this comment or this commentary, this documentary. We can't allow these documents to go out publicly. So what we're going to do is invoke our privilege. Perkins Coie is on the other end of that agreement. So they're going to say, well, we have to abide by that privilege. They're saying to aid the court in the instant motions, Perkins submits the declaration of Patrick Benedict to provide information about the attorney-client privilege and the work product claims that are being asserted by the actual clients, the DNC, Hillary for America, and then Tech Executive Number One. They're the clients. They're asserting the privilege. We see here Patrick Benedict is going to be somebody who's over with Perkins Coie, who's going to come out and say, yeah, this was all law work, legally related stuff. So it falls within the work product doctrine and it should be privilege. For the foregoing reasons, they say we're going to join GPS, FusionGPS, and ask the court to deny the motion to compel. And finally, here we have Hillary for America, motion to intervene. You see Robert P. Trout is entering his notice of appearance, along with Paola Pinto appearing for Hillary for America. This is their motion to intervene, and we've got several different declarations that we can peer into. Of course, John Podesta, very closely connected to Hillary. Robert Mook, also same story back in 2016. And then the declaration of Marc Elias, the campaign lawyer connected with Perkins Coie, we've already talked about. You see here that they're filing a motion and declaration supporting a response to the motion to compel. This is the motion from John Durham saying, give us those documents. They're responding to this. They're saying they want this response ex parte, in camera, under seal, saying that, we need to really kind of make sure this stuff is highly limited. Ex parte, meaning we're just going to send this to you, judge. We're not even going to send this to the prosecution, meaning they don't want the government to know about it. They also are asking that this is done in camera and under seal so that the judge only is the only individual who gets to see it. And it's under seal so that you don't get to see it. None of us get to see it, so that it all is too sensitive for all of us. So we can see that we've got several different declarations to go through. This is the original motion to intervene coming out from Hillary. Says, all right, now that our name is being dragged through the mud, according to them, because Sussmann is being prosecuted, they say we have to file this motion. It's made by Hillary for America and the DNC, and we're asking to file this ex parte, meaning we're not going to copy the prosecution on this. We're only going to send our response to you, judge, because it's just too sensitive. We want to file it under seal, and we want the court to do a review in camera, behind closed doors, on your own. And this is what they're asking the court for permission to do. File the attached declarations with Robert Mook and John Podesta, which we're going to take a look at, but then file Marc Elias's affidavit and declaration under seal, ex parte. You'll see what I mean here in a minute. We can see declaration of John Podesta is as follows. We get to see it. There's no redactions here. Nothing to seal. Not a big deal. Here he says, I'm John Podesta. I'm competent to provide testimony on this issue. In 2016, I was chairman of and president Hillary for America. Although it's no longer active, I'm the chairman to wind up its affairs. Says, when you ask me about this relationship between Perkins Coie and Hillary and whether attorney-client privilege should exist and all of these things, Podesta's saying, oh yeah, of course, it was all attorney-client privilege. It wasn't a fake collusion hoax or anything like that to swing an election. No. It was legitimate attorney work product doctrine, at all times relevant to the government's pending motion. Perkins Coie served as general counsel to the HFA, right? He's declaring this. To my knowledge, Perkins Coie has consistently maintained the confidentiality of documents and information covered by attorney-client privilege. In other words, they didn't crack the shell. If you breach attorney-client privilege, there's good argument that you've breached it. There's nothing else to protect. Once that information is out there and that privilege is broken, well, it's hard to put the genie back in the bottle afterwards. And here he's saying, no, they've never broken that shell. HFA, Hillary for America, also asserts its attorney-client privilege and attorney work product protection with respect to all documents and under the control of Perkins Coie or any other consultants, including FusionGPS. So John Podesta, a campaign person, is now out here saying, we're invoking everything. What are you kidding me? Yeah, I'm still working president chairman for Hillary for America. We're invoking. Yeah. So Judge, here's my declaration, just so you know. He says HFA is not waiving any of its privileges, and it opposes the government's motion to compel that was filed on April 6th, saying we're the holders of this privilege and we're invoking it. And you don't have a right, Judge, to now encroach on that by forcing us, compelling us to give you these documents. We're going to be maintaining and asserting those. And we've got some more documents we want to send you, Judge, but we don't want to send the prosecutors and we don't want to make them public because we don't want anybody to see about them. We then have the declaration of Robert Mook. He says along the same lines, I'm also competent. Beginning in 2003, says, I became employed in presidential campaigns on behalf of Democratic candidates, and I've worked on them ever since. When Secretary Hillary announced her candidacy, he was just doing cartwheels in his living room. He says, I was appointed campaign manager for campaign for Hillary, which is known as HFA. I had responsibility for day-to-day management of the campaign and blah, blah, blah. Writes, when HFA engaged Perkins Coie as its general counsel in April 2015, Donald Trump hadn't announced yet. He announced shortly thereafter in June. But by April, Donald Trump had a significant lead in the delegate count for the Republican nomination. It seemed highly likely that he would eventually be the Republican nominee for 2016. One of the topics about which Perkins Coie provided legal services and legal advice to HFA involved fact-finding and research that the campaign conducted regarding Donald. Although I was not aware during the campaign of any contractors that Perkins Coie engaged with, like Fusion, engaged to assist it in providing legal services and legal advice, I did believe throughout the campaign that whatever work Perkins Coie performed, either through its own professionals or any other contractors, were done for the purposes of providing legal services and legal advice. Not to, write fictional narrative stories about Russian collusion. No. All legitimate, bona fide legal services. And therefore, it's all protected. And so, Judge, since we have a declaration from Robert Mook and John Podesta, well, how are you possibly going to be encroaching on this very important privilege? We'll see. We see here that we've got another entry, a motion to file portions of the declaration of somebody very important under seal, in camera, under seal, so that you can't see it and we can't see it. Here, this person, of course, is Marc Elias. They say on April 6th, 2022, the government filed a motion to compel, seeking the governments from HFA, the DNC, and Perkins Coie. They write, and FusionGPS, a consultant hired by Perkins, all withheld all of those documents based on this privilege. In the motion to compel, the government challenged the assertion of the privilege. Here, HFA and the DNC are holders. So they say, and they tell us, here, HFA and the DNC respectfully request the court permit them to file on ex parte in-camera basis under seal the portions of what? The declaration from Marc Elias. We're going to go through that. Huge portions that we can see are redacted. So we actually cannot see them. But this is what Hillary is asking permission to do, is to say, this stuff that we can't see, Judge, we're going to send this over your direction, ex parte, in camera, under seal. Is that appropriate? Yes or no? Here's what it looks like. The declaration from Marc says, I'm Marc. I went to Duke University. From 1993 until September 2021, I was an attorney at Perkins Coie. I became the chair of the political law group. During my career, I've represented hundreds of Democratic candidates, a number of political action committees. I've litigated scores of cases. He continues, paragraph 3, we start to see some redactions. This is what I'm talking about. Under seal, ex parte, maybe not even going to the government in these cases. In 2015, Coie was retained by Hillary, the principal campaign committee. He says, I served as the firm's client lead for the Clinton campaign and held the campaign title general counsel, where I did something, fill in the blanks. From 2009 until 2021, the firm also served for the DNC, where I did other Democratic filthy things. He continues, says paragraph 4, from approximately 2009 until 2021, I also served at the DNC as counsel to political committees. The firm and I routinely advised campaigns on all sorts of stuff, finance, defamation. We defended clients in litigation. I worked for John Kerry back in 2004. It was well documented that there were false claims attacking Senator Kerry's service. He's still hot about that one. Similarly, in 2008 and 2012, we represented Barack. He says here that Donald Trump became a leading figure and he began promoting a lie that became known as birtherism. For example, he says in March 2011, Trump told Fox News that Obama didn't have a birth certificate. He continues on talking about the context of the 2016. He says, I'm generally aware that Trump was involved in an exceptionally high number of lawsuits. He says, I recall during the Republican primaries in 2015 that Trump threatened to sue a political committee supporting John Kasich. In 2016, both the DNC and the Clinton campaign maintained large research staff, all dedicated to Trump, his background, his public statements. During this period, the DNC and Clinton maintained large communication staff. Their responsibility was to disseminate statements from Hillary. And so he's going back through this. As to the best of my election, I would estimate that over 2016, more than 100 people worked in these two departments. Paragraph 9, don't know what that says. He continues, and we can see a lot of this is background. He says, paragraph 11, at some point after the meeting, Perkins Coie engaged with Fusion. As general counsel for the Clinton campaign, I recall thinking that the expertise that could be provided by Fusion would aid me in my work for my client. He's the lawyer. He's justifying the use of his expert witness consultants. I provided FusionGPS direction on the research and the information I thought would help me perform my job. So it's all just lawyer talk. This is what you have to say in order to say why you need that consultant, that expert. And you can't just say, here's $5,000, go figure something out for me. You've got to direct it. You've got to tell them what you're looking for. That means you're engaged in attorney-client work. He writes, Fusion and their work was distilled and incorporated into my judgments. Oh yeah, his legal judgments about a hoax. He says, for example, as a hypothetical, of course, if I thought that the Clinton campaign or the DNC was likely going to want to make a public statement about the way the Scottish population was treated, then I would develop a line of questioning around that. So general consultant stuff. But then we see major redactions. Paragraph 13, by the way of background, by the summer of 2016, public knowledge and my understanding, he says, that the DNC and at least one other Democratic organization hacked by the Russians. He says, I recall the materials stolen during the hacks were being publicly disseminated in a manner that appeared to assist candidate Trump. I recall around that time at the Democratic convention, Trump publicly encouraged Russia to take action on releasing Hillary's emails. And then no more information for us. Womp womp redacted. Probably saying, and you know, Trump is an evil monster, orange maniac. I was doing this out of the goodness of my heart. Paragraph 14. Had no idea it was a hoax at all. Hillary Clinton's the honest candidate that we needed. Paragraph 17, that the Russian and Putin are responsible for everything miserable in my life. And paragraph 18, whatever. You can see this wraps up. Executed on 4/18, signed under penalty of perjury. The following is true and correct. Don't know what any of that is. Hillary saying, can we file this ex parte so that the prosecution can't see any of that either? Can we file this under seal so that you can't see any of this either? We'll see what the judge says. We know that there is a new hearing scheduled for April 20th coming up. There's going to be several of these. The judge reset another one, looking like this one is coming out April 27th at 2 p.m., courtroom 27A. Another motions hearing, because both sides have filed just a ton of motions in limine, motions to try to deal with some of the preliminary issues, because boy, we've got trial coming up real soon, taking place in May. We're going to continue to follow this case in depth. There's going to be a whole slew of motions, responses, and replies coming out over the next several weeks in anticipation of trial, and we're going to follow it all, and I hope you join us on that journey. I would love it if you subscribed before you got out of here, because I look forward to seeing you on the next one.